The Supreme Court of the United States just declared that Donald Trump collected $166 billion from American importers illegally. Arguably, not controversially, illegally. 6 justices, including 3 appointed by Republican presidents, said so in black and white on February 20th, 2026. Chief Justice John Roberts, writing for the majority, delivered the verdict in a single sentence that will echo through trade law for a generation. Those words cannot bear such weight. Those words, the 2 words, Trump's entire trade war rested on. The authority he claimed gave him the power to tax every import from every country on earth through a 1,977 emergency statute. Gone, struck down, declared unconstitutional in its application. But here's what the news coverage is missing and why the story is bigger than the headlines suggest. The $166 billion didn't come from foreign governments. It didn't come from Canada or China or the European Union. It came from American businesses, importers who paid those tariffs at the border and passed the cost directly to you. Every car part, every aluminum can, every piece of Canadian lumber, all of it going to the U.S. Treasury, all of it. The court just said taken without legal authority. Over 2,000 importers have filed lawsuits in the Court of International Trade. Penn Wharton estimates total refund liability at $175 billion. On March 5th, the CIT issued its first order directing refund of EA duties. But while Washington scrambles over who owes what to whom, something far more consequential is happening in Ottawa. Mark Carney's government isn't watching this legal chaos unfold from a distance. They're weaponizing it. They're taking America's own legal framework, the same statutes Trump used as weapons, and turning them against Washington in a counterattack that U.S. trade lawyers are calling the most sophisticated a U.S. ally has ever deployed. In the next few minutes, I'm going to walk you through exactly what the court killed, what Trump scrambled to replace it with, and the 3-pronged legal judo move Canada is executing one that could cost the U.S. hundreds of billions in refunds and permanently constrain Washington's ability to weaponize tariffs against its closest ally. And I'm going to show you why the tariff war didn't tax Canada, it taxed you. And the court just confirmed it was illegal the entire time. If you care about where your tax dollars are going, subscribe now and hit that bell because this story is far from over. Let's be precise about what died on February 20th because the coverage has been incomplete and Washington is counting on you not understanding the details. The EA tariffs were not a niche policy. They were the backbone of Trump's entire trade war. The broadest tariffs in modern American history, covering virtually every import from virtually every country. The fentanyl tariffs on Canada, Mexico, and China imposed under a declared emergency about drug trafficking dead. The Liberation Day reciprocal tariffs imposed under a declared emergency about trade deficits dead. Every tariff deal Trump negotiated with Japan, the UK, and South Korea, where foreign governments agreed to make investments in exchange for reduced tariff rates. The court's reasoning was devastating in its simplicity. EPA allows the president to regulate importation during an emergency, but the power to impose tariffs is very clearly a branch of the taxing power. And the Constitution gives that power exclusively to Congress. Roberts invoked the major questions doctrine, the same principle used to strike down Biden's student loan forgiveness. If Congress wants to give the president power of vast economic significance, it must do so explicitly. An ambiguous word in a 1977 statute doesn't count. The fiscal hole, $1.4 trillion in projected revenue over the next decade, gone in a single ruling. But the legal exposure is even bigger. Because the moment EPA died, the clock started on refund litigation, and Canada saw exactly what that clock meant. Within hours of the ruling, Trump scrambled to replace what the court had taken away. He invoked Section 122 of the Trade Act of 1974, an obscure Cold War provision allowing a 15% temporary tariff for 150 days to address balance of payments deficits. Let me explain why this is a paper tiger. Because the details matter. Section 122 is capped at 15%. down from the 25 to 50% rates Trump had under EA. It expires in 150 days, meaning July 2026, the exact same month the KSMA review opens. The House of Representatives already voted to repeal Trump's Canada tariffs while the EA fight was ongoing, and 24 state attorneys general filed lawsuits challenging the Section 122 authority within weeks of its invocation. The administration also pivoted to Section 301, the Unfair Trade Practices statute, launching the broadest investigation in its history against 15 economies under the charge of structural overcapacity. Section 301 requires evidence, hearings, and comment periods. Months of process, not the instant weapon IEPA was. Section 232 tariffs on Canadian steel, aluminum, and autos remain in place on a separate litigation track. Tariff whack-a-hole in real time. One authority struck down, another invoked. Lawsuits follow. Businesses can't plan. Prices can't stabilize. At every turn, Canada's legal team is watching, documenting, building a case. Subscribe right now, because the move Carney made in response to all of this is the part that has Washington's trade lawyers genuinely alarmed. Here is what Ottawa's legal team reportedly presented to Carney's inner cabinet in the days immediately following the Supreme Court ruling, and why sources close to the U.S. Trade Representative's office are describing it as the most sophisticated counterarraignment strategy a U.S. ally has ever assembled. The strategy has 3 prongs. Each one uses America's own legal framework as the weapon. Prong 1, the refund offensive. Canadian exporters and their American import partners paid billions in EA tariffs the court just declared illegal. Ottawa has publicly advised businesses to review U.S. entry data and file protests to preserve refund rights. Canada is providing legal coordination, connecting exporters with U.S. Trade Council, and building a systematic claims apparatus. Every dollar recovered weakens the tariff regime's lasting damage. Every dollar documented strengthens the legal record for what comes next. Prong 2, the WTO and CUSMA challenge matrix. Canada filed WTO proceedings over steel and aluminum in March 2025, a second challenge over auto tariffs in April. The Supreme Court ruling just transformed both cases. Canada can now argue that America's own highest court found the tariff regime unauthorized by domestic law. If it wasn't legal under American law, how can it be justified under international trade commitments? The argument was strong before February 20th. After February 20th, it is airtight. Prong 3. And this is the move that has Washington scrambling. Canada is building a Section 301 style case in reverse, not using Section 301 itself, that's an American statute, but using the same evidentiary structure, the same framework of argument to build a comprehensive case at the WTO and through KSMA dispute mechanisms that America's tariff regime constitutes unfair trade practices under international law. Trump's favorite weapon pointed back at the hand that invented it. Here is the evidence Canada is reportedly compiling, each exhibit more damaging than the last. Exhibit A, the EA tariffs were imposed without legal authority, confirmed by the Supreme Court of the United States. Imposing illegal taxes on a treaty, partners' goods for over a year, collecting $166 billion from the economy in the process, is by any definition an unfair trade practice. The U.S.'s own highest court provided the documentation. Exhibit B, the 100% tariff threat against Canada over the China deal, a threat Trump's own advisors internally flagged as unimplementable. Using tariff threats as political punishment for a sovereign nation's independent trade decisions violates the principle of most favored nation treatment under WTO rules. Canada signed a trade deal with China. Trump praised it. 8 days later, after a standing ovation at Davos, he threatened 100% tariffs on all Canadian goods. Same deal, different emotional state. That 8-day reversal is now evidence. Exhibit C, the Section 232 tariffs on Canadian steel and aluminum imposed under a national security justification that America's own allies have described as legally incoherent. Canada is a NATO founding member. It shares NORAD with the United States. It has fought alongside American soldiers in every major conflict since the First World War. Designating Canadian steel a national security threat has no credible legal basis, and the WTO has already ruled against the U.S. on this issue in cases brought by other countries. Exhibit D, the cancellation of trade negotiations as punishment after Ontario aired a television advertisement using Ronald Reagan's own words to criticize tariffs. Terminating treaty-based trade talks in retaliation for constitutionally protected political speech has no precedent in the history of international trade law. Exhibit E, systematic economic coercion, tariff threats, asset freeze threats, 51st state rhetoric to undermine the sovereign equality of a treaty partner, a violation of the foundational principles of the rules-based order the United States itself built after 1945. Sources close to Canada's trade ministry describe it as the legal equivalent of a siege. Not one case, not one forum, but a coordinated offensive across the WTO KSMA panels and U.S. federal courts. Each ruling becomes evidence in the next proceeding. The accumulated record points to one conclusion. The United States systematically violated its own laws, its own court rulings, and its own treaty commitments. Canada wants to be made whole. Now, let's talk about the money, because the numbers are staggering and the mechanics matter. Penn Wharton projects total EPA refund liability $175 billion. Legal analysts estimate Canadian linked claims could represent $8 to $15 billion of that pool based on trade, volumes, and tariff rates applied to Canadian goods. When you step back from the noise of politics and look at the situation the way an investor studies a balance sheet, the strategy becomes clearer. The refunds from these tariffs do not go to foreign governments or even to the exporters who sold the goods. They go to the importer of record, the American company that paid the tariff at the border. That small legal detail is what makes the strategy so interesting from a long-term, almost chess-like perspective. By quietly helping American importers file refund claims, Canada accomplishes several objectives at once. First, it helps repair the economic damage that tariffs cause to cross-border supply chains. When an importer receives a refund, that money often flows back through the business relationship, back to suppliers, distributors, and exporters who share the same commercial ecosystem. In practical terms, part of that recovery eventually finds its way back to Canadian producers who lost business during the tariff period. But the more subtle outcome is political rather than financial. When American importers begin recovering billions of dollars through legal claims, they develop a direct financial incentive to oppose future tariffs on Canadian goods. Auto manufacturers, construction companies that rely on Canadian lumber, industrial buyers of steel and aluminum, these are not abstract actors. They are large employers with lobbying operations, relationships with lawmakers, and real influence inside Washington. Once their balance sheets are tied to the outcome of tariff litigation, their interests naturally begin to align with a more stable and predictable trade relationship. In other words, the legal fight slowly creates an internal American constituency that prefers cooperation over trade confrontation. From a strategic standpoint, that is a powerful alignment of incentives. There is also a third layer to the strategy that matters in the long run. Every refund claim filed by an importer becomes a documented data point in the broader legal record. The litigation process does not simply return money. It produces evidence records of payments, supply chain disruptions, and economic losses. Those records strengthen arguments in international trade forums such as the World Trade Organization and under regional agreements like the United States-Mexico-Canada agreement. More than 2,000 importers have already filed lawsuits, with hundreds more cases following behind them. Each case adds another line to the ledger, and in legal disputes, a detailed ledger often becomes the most persuasive argument. While these cases move through the courts, the broader trade environment remains unusually unstable. One set of tariffs disappears after a court ruling, another appears under a different legal authority, and new investigations promise future measures that may or may not survive their own legal challenges. From a business perspective, this kind of policy volatility is costly. Companies cannot plan long-term supply chains when the price of imported materials may change every few months depending on the next court decision or regulatory action. When manufacturers face unpredictable costs for steel, auto parts, or lumber, those costs inevitably show up somewhere else in the economy. They appear in the price of a car, the cost of a refrigerator, or the expense of renovating a home. Economists often point out something that is easy to miss in political debates about tariffs. Tariffs are usually paid domestically. The importer writes the check to the government, and the cost eventually spreads through the economy in the form of higher prices. That means the financial burden rarely lands where many people assume it does. Over time, the cost is distributed across businesses and households through supply chains and consumer prices. Even if courts eventually order refunds to companies that paid tariffs, the higher prices consumers experienced along the way are not something that can easily be reversed. In economic terms, those costs become part of history, much like a temporary tax that quietly moved through the economy. Looking ahead, there are several possible paths this dispute could take. One possibility is the slow path of legal attrition. Trade cases work their way through domestic courts, international arbitration panels, and treaty mechanisms over several years. Each ruling builds precedent, gradually clarifying what governments can and cannot do under trade law. That outcome tends to be slow, but it produces the kind of legal certainty that businesses prefer. Another possibility centers on the next major review of North American trade relations under the United States-Mexico-Canada Agreement. Trade agreements are periodically revisited, and moments like that often become opportunities for governments to renegotiate rules or strengthen dispute resolution mechanisms. A third possibility is less orderly: continued cycles of tariffs, lawsuits, and countermeasures that gradually push companies to diversify their supply chains away from North America altogether. When uncertainty persists long enough, businesses eventually look for stability somewhere else. From a long-term investor's perspective, the real issue here is not just about refund checks or even the size of the economic losses involved. The deeper question is whether trade agreements and legal frameworks provide reliable rules for economic cooperation. Markets function best when participants believe that the rules of the game are clear and consistently enforced. When governments test those rules through aggressive policies, emergency authorities, or retaliatory trade measures, the system eventually relies on courts and dispute mechanisms to restore balance. In the end, the story is less about a single policy decision and more about how institutions respond when the boundaries of authority are tested. If the legal process ultimately determines that certain tariffs were imposed improperly, the consequences will likely extend beyond the immediate refunds. They will shape how future administrations approach trade policy, how businesses evaluate risk, and how international partners view the credibility of economic agreements. As in investing, the long-term outcome depends not only on what happened yesterday, but on the precedent that guides decisions tomorrow.